statistics, less than 10% of the medical malpractice claims made against health professionals are referred to a further inquiry for action. Now, these statistics were revealed in the Health Professions Council of South Africa's annual report for the 2022-23. It's led to questions questions being raised regarding what seems to be a high number of cases which are unfounded that flood the system. For more on this, I'm joined by JP Ellis, who's the head of claims and legal at EthiQal. JP, a pleasure to have you on the program this afternoon. Now, the statistics highlight a significant number of unfounded cases against healthcare professionals. How does this impact the overall trust between patients and doctors, and what measures can be taken to rebuild this trust?
Thanks so much, and thanks to your listeners for the opportunity. I mean, it is a vexed question because there's no easy answer, but essentially let me start at the beginning. So the Health Professions Council of South Africa is essentially the governing body that regulates the healthcare profession, and part of their mandate is also to protect the public. So typically complaints against healthcare practitioners would be sent or addressed to the healthcare professional society, healthcare profession, and they would have to screen, investigate, and enforce any allegations of unprofessional conduct. Now, unfortunately, what tends to happen is that the Health Professions Council, their regulatory process is quite slow and inefficient, and so often what you find is that those processes are delayed or unresolved. So when we see these small percentages of matters that are actually being taken to an inquiry, it suggests that a large amount of cases are accepted, or the explanations are accepted in favor of the doctor, and that very few matters actually proceed all the way, which suggests that many of the cases are either unfounded or ill-considered. Certainly from our perspective, we see a lot of these unfounded and ill-considered cases. And then the consequences is that the patient's health is left compromised, and the doctor's well-being is also being subjected to, obviously, a negative consequence.
Mr. Ellis, the concept of medical malpractice stress syndrome is also quite intriguing. Could you delve deeper into how this syndrome manifests and also the long-term effects it may have on the mental health of healthcare professionals themselves?
Yeah, so, I mean, one has to always consider the following, that for the doctor, one of the first rules that they learn as part of the oath that they take is to do no harm. So doctors don't intend going out and harming patients. Their first point of call is to obviously treat patients and give them the best care available. But one must also consider that doctors operate and work under tremendous stress and challenging circumstances. Many of them don't sleep. There's a lack of resources. We have a overburdened healthcare system. It's quite endless, actually. So for the doctor, it's a real challenge when they are confronted with these allegations, because it does put them in a situation where their professional reputation is being questioned, their competence and ability is also being questioned. And in some cases that we do see, those cases are unfounded or ill-considered. So it does have an impact on the doctors, whether it leads to depression. In some instances, it might escalate to criminal complaints, and that also has a negative consequence and impact for doctors.
So in your experience, how do these ill-considered allegations then contribute to the critical shortage of doctors in the country, and what steps can be taken to alleviate the shortage? Yeah,
I mean, what people need to understand is that medicine is not an exact science. The human anatomy is a complex machine. So whenever there's a medical intervention or healthcare treatment being delivered, there's always risk involved, even under the best hands and the best qualifications. Complications do occur. And the Americans have coined this phrase, to err is human, and that's the reality. Sometimes mistakes do happen, and sometimes there are adverse incidents or outcomes that are less than ideal. But not every error or adverse outcome equates to negligence. So that's the difficulty that we sit with, that our courts have also cautioned that the natural human tendency is to blame someone when a person is injured. And in our case, what the law requires is that doctors should employ a standard of reasonable care. Their care or treatment is not intended to be perfect, recognizing the limitations of our understanding of the human body. So it is difficult to make that assessment whether or not there is negligence. But the overall perspective from our view is that the patient has a responsibility as well. As much as the doctor has an obligation to treat them in a reasonable fashion and employ reasonable skill and care, the patients themselves also have a responsibility to look after their health and to comply with the recommendations, come for follow-up appointments, be compliant. And we see a lot of that patients aren't compliant. They don't understand that they have a dual obligation. They have an obligation as well to care for themselves. And so when things go wrong, rather than proceeding with legal action or threatening the doctor to complain to the Health Professions Council, rather adopt an approach of discussion, open dialogue with your doctor, try to get the answers from the doctor. And obviously, one must recognize that patients are entitled to complain. They are entitled to take action for wrongful conduct and request compensation. But in our experience, many patients resort to legal action as a first port of call rather than a matter of last resort.
Mm-hmm. So as EthiQal, the organization also emphasizes the importance of open dialogue between patients and healthcare professionals. Can you share successful examples where this open communication has prevented unnecessary legal proceedings and also fostered a better understanding?
Yeah. I mean, like I said earlier, I mean, you'll find that doctors generally don't intend harming their patients. In fact, the first point that I made was that to do no harm. And you find that healthcare practitioners are genuinely interested in good outcomes for their patients. So the doctor-patient relationship is built on trust, it's built on understanding. There's a patient's healthcare charter, and in terms of that charter, the patient has a responsibility to work with the doctor and to foster open dialogue with the practitioner. So one must also understand that a lot of these type of cases are time-consuming, emotionally draining, and it leads to unintended consequences like pushing up healthcare costs. So certainly from our point of view, we adopt an approach of mediation, being proactive, trying to resolve the matter rather than being adversarial, and trying to restore the doctor-patient relationship. And one tends to find that in a lot of those situations where the doctor himself maintains that dialogue, that open communication, and when we get involved, we try to do the same and follow that same route of working with the patient to try and resolve the issue. You find that those are the matters that have the best success, or at least they're open-minded in trying to resolve. So mediation has always been punted as the better way of resolving matters because it's less adversarial, or there's no adversary actually, but it's a voluntary process, so it requires the buy-in of all the parties involved. And those are typically the matters that allow us to have the best success. And ultimately, it's for the betterment of society in general and lowers healthcare costs.
Also interesting is that the Health Professions Council of South Africa has also acknowledged delays and inefficiencies in their processes. How can these regulatory processes be improved to ensure a fair and timely review of cases while also maintaining the quality of assessments as well?
Yeah, I mean, most regulatory bodies have a very difficult job having to regulate a particular profession. They are what we call a creature of statute, so they limit to what they can do in terms of the regulation and the legislation. So, I mean, the Health Professions Council is no different to any other regulatory body. But fortunately, they are open-minded. They recognize that there are shortcomings. But it does seem that they're willing to address those issues. Certainly from our perspective, we saw in June this year that they adopted new regulations which are intended to speed up the processes and to try and get matters to a conclusion in a more effective way. So certainly they're taking up the mantle and they are trying to be proactive. So one must commend the HPCSA in that regard.
So also interesting is that the Minister for Health has also highlighted a low doctor-to-patient ratio. How can addressing the issue of unfounded cases then contribute to a more sustainable and resilient healthcare system for the country? Yeah,
I mean, that's a whole conversation on its own, but we do find that our South African healthcare system is overly burdened. There are instances of doctors immigrating, doctors taking early retirement or reducing their scope of work, and that's both in the public and the private setting. So yes, I mean, we should be alive to the fact that we have a overly burdened system. There are challenges, but I mean, all is not lost. There's many different initiatives at industry level which are trying to improve the quality of our healthcare system, and certainly EthiQal from our point of view. We're looking at improving and assisting whichever way we can in that initiative of improving the healthcare system for everybody.
JP, as we wrap up our conversation, you've also suggested that legal action should be a last resort. Can you elaborate on alternative channels for conflict resolution and also communication that have been explored before resorting to litigation?
Yes, I mean, one must always remember that most doctors, or at least, I mean, probably the majority of healthcare professionals, usually have an open door policy. And sometimes what we find is that, you know, in cases of litigation, people are quite hasty when they threaten legal action. It's something that's just developed over time. You see that people resort to that type of, you know, when they get angry, they threaten to sue you. But one must understand that, you know, matters can be resolved in a more collaborative way. One must understand that there are more than one issues at play. You might be dealing with a healthcare establishment like a hospital. There might be multiple medical practitioners involved or a multidisciplinary team. So sometimes the issues are a lot complex, more complex than what you think. So simply going and suing everybody is not really the best solution. Having open dialogue, having the conversations, being open-minded in your approach to resolving the matter. In many instances that we see, having a meeting with a doctor, voicing your concerns is generally the best way of taking that next step to understanding what the issues are and resolving it. Because at the end of the day, it's the patient who suffers. It's their health that's compromised. And if many doctors are leaving the profession, you're going to find a lot of patients who are unable to get the health care that they require.
JP, thank you very much for your time. That was JP Ellis, who's Head of Claims and Legal at EthiQal, also highlighting that the healthcare system is burdened by a number of cases related to unfounded cases of medical malpractice.